by law. Still on the go.
Hey guys, so for today's video, we will answer the questions that you sent to us, wherein I and my team will help you understand the section 26, the paragraph 1 to 6 of the E-Commerce Act in chapter 3. So let's start. So the first question is, are electronic messages and electronic documents can be a valid substitute for a paper document? So I think Miss Bontogon will answer this. Miss Bontogon?
Well, yeah, but before that, I am Leifer Bontogon. Also, before I answer the question, Electronic Commerce Act Section 26 is all about transport document. And let us define it first. So, transport document. It means a document which evidences a contract of carriage and the taking over or loading of goods by a carrier, made out in the form of bill of lading or consignment note or of any other document used in trade. It is a document used to convey information or a proof about the cargo that is being transported from one place to another. It usually lies at the heart of the international trade transactions, and these kind of documents are being issued by the shipping line, airline, international tracking company, railroad, freight forwarder, or logistic company. Also, it is stated in paragraph 1 under section 26 that where the law requires that any action referred to contract of carriage of goods in section 25, which is discussed in other video, be carried out in writing or by using a paper document, that requirement is met if the action is carried out by using one or more data messages or electronic documents. In simple words, electronic messages or electronic documents can be used in lieu of paper documents. In some cases, such as when a shipping company is to issue a receipt of goods to the buyer, they can use electronic messages or electronic documents instead of paper document, since it is acceptable based on this paragraph as long as such instances is connected to section 25. In addition to that, in paragraph 2, stated that paragraph 1, which I shortly explained, applies whether the requirement there is in the form of an obligation or whether the law simply provides consequences for failing either to carry out the action in writing or to use a paper document. As to based on how I do understand this paragraph, the use of electronic messages or documents in lieu of paper documents is in form of obligations or utang. Also, if the law has given orders to issue an electronic messages or electronic document, if a shipping company failed to use paper documents. So to answer this question, yes, electronic messages and electronic documents could be a valid substitute of paper documents. Again, as long as such cases are connected to section 25. Also, someone asked, what would be the basis in order to effect the requirement required by law if the right is to be granted or an obligation is to be acquired by one person and no other person?
I think I can answer that one. So in paragraph 3 of section 26, stated that the requirement is satisfied where the right or obligation is carried through the use of electronic information created by a method that gives reliable assurance that the right or obligation has become the right or obligation of that person or no other person. So, if a right is to be granted to or an obligation is to be acquired by one person or no other person, and if the law requires that in order to effect this, the right or obligation must be conveyed to that person by the transfer or use of a paper document, that requirement is met if the right or obligation is conveyed by using one or more electronic data messages or electronic documents, provided that a reliable method is used to render such electronic data messages or electronic document is unique. And another question is, What is the required standard of reliability in Section 26, Paragraph 3 of Electronic Commerce in Carriage of Goods? So the standard of reliability required shall be assessed in the light of the purpose for which the right or obligation was conveyed and in the light of all the circumstances, including any relevant agreement. So it means that for the purpose of paragraph 3, whether an assurance is reliable, it must be determined in view of all the conditions required, including the purpose for which the right or obligation was carried and any other relevant agreement.
So the next question is, what will happen if the electronic documentation or electronic message or data turns to paper documentation? So I am the one who will answer the question. So first, here is the content of the section 26, paragraph 5. If we summarize that paragraph, the paper documentation is valid if the electronic document is terminated and replaced, and the paper document to be issued contains the statement of the termination of the electronic documentation or the electronic data message, and it does not affect the rights and obligation of the parties involved, whether the replacement is e-documentation or the paper documentation. So the paper document here must be valid only if the electronic documentation is terminated or replaced. Maybe that would be also the answer of the question. So if we answer the question, what will happen if the electronic transaction turns to paper documentation? My answer is the electronic transaction must be first terminated and replaced before the paper documentation becomes valid, or according to the content of the section 26 paragraph 5, no paper document used to effect any such action is valid unless the use of electronic data message or electronic document has been terminated and replaced. And for the last question will fall to the only man in our group, Mr. Resusta.
Yes. So it was being asked that what will happen if a rule of law is compulsory applicable to a contract of carriage of goods which is in or is evidenced by a paper document. So under Section 26.6 of Republic Act 8792 or E-Commerce Act of 2000, if a rule of law is compulsory applicable to a contract of carriage of goods which is in or is evidenced by a paper document, that rule shall not be inapplicable to such a contract of carriage of goods which is evidenced by one or more electronic data messages or electronic documents by reason of the fact that the contract is evidenced by such electronic data messages or electronic documents instead of by a paper document.
It is nice that each of one of us answered the questions that you sent to us, guys, and hopefully nakatulong yung mga sagot namin for you to able to understand more about the section 26 paragraph 1 to 6, and hopefully hindi naman nakagulo palalo yung sagot namin. And I think that's all for today, guys.
Well, we think so too. And for more law videos, you can drop your questions in the comment section.
Yes, of course, because we will answer that as long as we can.
So see you everyone. Don't forget to like, subscribe, and hit the notification bell.
Thank you for watching!